Dr. Senior.
No, no, that should be the, we like that with in the bar.
Lordship, last week I have mentioned one case for listing the matter, but it is not yet
It hasn't been listed.
listed. No, Lordship. On 31st, Lordship, Saturday.
Fifth,
Oh, Kulas.
fifth. On 5th of September.
Lordship, then I will mention next week because I will be out of station for some day. That is why.
Okay. 31st, little I have some
Difficulty. Yes, Lordship.
Lordship.
On 5th, Lordship.
If you have any difficulty, then fifth.
Yes, I will. Again, I will mention Lordship.
Lordship, we had filed a 528 petition challenging the order of the CGM Diva House of taking cognizance of the case because on behalf of the Army Lordship, they are protected under the Special Power Act. That is, lower court has fixed the matter on 3rd Lordship. So may be taken up on Saturday Lordship. It is fixed on 3rd before the lower court Lordship. Yes.
Okay,
Oblige your Lordship.
maybe. Lord, I have filed a criminal appeal, my lord, against acquittal. So there is a leave petition there. So it was listed on, my lord, last 6th of February. Therefore, it is not listed. So my pray it may come on. 9. And another, my lord, I have filed a bail petition in pending case, my lord. Earlier it is pending for 6, my lord. So it is regarding POCSO, my lord. And he is in jail about 2 years. Okay.
10th.
Yeah.
The bail matter on 10th.
Well,
This matter on 9th.
Please, your Lordship. I beg to mention item number 33, my lord. My lord, with the consent from the other side, my lord, I prayed for my lord 1 day accommodation, my lord, only for today, my lord. I also file my lord prior intimation also.
Yes, Mr. Bachaji, you are there.
I'm put
Relief on the date to be fixed.
Must.
one criminal petition, my lord. It was last listed on 10/5/24, my lord. Urgency is there, my lord. One serviceman is there, my lord. But this case has been, complaint case has been filed, my lord, against this service person also, my lord. So matter may come subject to lordship convenience, my lord. Every time it is listed, but not reached, my lord.
Make a mention in the morning itself when the matter is listed on the day.
Yes, my lord. Date, my lord.
On 10th,
Obligement.
you make a mention in the morning.
Yes, my lord.
May I please, your Lordship, my lord, I beg to mention item number 9, my lord. My lord, due to medical purpose, my lord, my senior could not appear, my lord. At least 2 weeks time, my lord, needed, my lord. 2 weeks or 3 weeks time, my lord.
Have you informed the other side?
My lord,
The counsel for the petitioner is undergoing medical treatment. Now they paid by the party. List after 3 weeks on a date to be fixed by the registry.
Maybe. I beg to mention for listing on criminal division petition, Lordship. Can it be listed on Lordship tomorrow or day after tomorrow, Lordship?
What is the, when the order was
Urgency is
passed?
there, my lord.
When the order was passed?
No, Lordship, a new matter, Lordship, for motion matter.
Pending matter.
Motion matter. New
When
matter.
did you file?
Lordship, today I filed, Lordship.
What is the urgency?
Urgency, Lordship, in this case, Lordship, London trial court closed the defense witness in 302 cases, my lord, and fixed on, Lordship, 2nd of September, Lordship.
When the order was passed?
Yeah,
When
London
did the
trial
London trial
court,
court close the defense witnesses? When?
Lordship, exactly, I do not remember the
So-
date of order, my lord. Can it be, Lordship? Otherwise, Lordship, London trial court closed the defense witness in 302 cases, my lord. Tomorrow or day after tomorrow, my lord. Motion matter, my lord.
Friday.
Friday, my lord. Most blessed.
May please, your Lordship, I beg to mention for listing of IA criminal in mean criminal division for implementing a legally on 2nd September.
Fifth.
Right,
Yes.
your lordship. My lord, I filed this criminal petition on 8th of April, my lord. It got listed once on 6th of May. And it was deferred, my lord. Maybe listed on, my lord, 2nd of September.
Second, not on second. Okay, on second.
Yeah, please, your lordship. I wish to mention item number 8. Lordship, can this taken on some other day? Consent from the other side is taken.
The 2 weeks. only need to be paid.
May I please,
Lordship,
Lordship?
kindly
I-
allow the interim to continue.
In that case, next week. Fifth.
May I please, Lordship?
Obliged.
I am listing for criminal revision petition the case was listed on 31st, but and supposed to be listed after 2 weeks, but not listed yet, Lordship.
31st of July.
Yes. Last listed 31st July.
What order was passed? On 31st, what order was passed?
Ordered not passed.
Tenth. On 10th.
Please,
Yes,
Your Lordship, that to mention item number 12. We will be filing our affidavit, our rejoinder today. See if that may be kindly be brought on record, Your Lordship. Item
Let the
number
matter
12.
reach. Let the matter reach.
Okay.
May I please, Your Lordship? I beg to mention item number 37 with the consent of the other side. My lord, they file one implement petition and another vacating of the interim order. I pray 2 weeks time to file objection, my lord. Therefore, let me, 2 weeks. I have taken consent from the other side. Third.
The prayer of the council for the party based on the on a daily basis.
My lord, the interim order may be continued. My lord.
13th. Listeners. Yes.
Obliged.
May I please, Your Lordship, I'm appearing on behalf of A. Nazari for the petitioner. Kindly, he's having some personal difficulties. Item number 46, kindly adjourn for the day.
These are for all the matters.
Yes, Lordship.
Let the matter reach, we'll consider the prayer. Don't let the
Lordship.
matter reach.
Obliged, Lordship.
May it please the Lordship. Lordship, on the last occasion, my lord, up-to-date case diary was called for, my lord, in this matter. I have learned that from my learned friend that this CD is not there. No?
CD is not there, neither a file is there. Could go, acknowledge.
What is happening? Why are you not getting the cities?
Lordship, may perhaps it has come, it is along with the CD in the office. Oh, acha, he has, he has called up the, he has inquired, but I think it has not come. Lordship will take it up tomorrow, Friday, Lordship will give a try. And he has already told the office people to find out. No, LCR is here, Your Lordship. In fact, it has come through the registry, I believe. And scan copy has come, LCR in 2 numbers.
LCR is there.
Uh-huh.
Last occasion.
But then it's there, no? Investigating officer,
Yes,
up-to-date status
yes,
report.
yes.
Acha, sir. Up-to-date status report. Who's up-to-date status? Hmm. It will have, it will. ক'ত মাজে আছে। কোন থানা? নুনমাটি থানা। অ', হয় নেকি? আচ্ছা, আচ্ছা, আচ্ছা। সুধি লাভ নাই ইহঁতক। কালি ৰখিও নাপালো। ইহঁতে একো নকৰে, তুমিহে নুনমাটি থানা ফোন কৰিব লাগিব। মানে এইটো ক'ত? আহিছে ইনষ্ট্ৰাকশ্যন বোৰ। আছিল ন লাষ্ট টাইম? কি বিষয়? কুলদীপ আছিল। কুলদীপ এইটোতো আছিল 1 নম্বৰটো আপ টু ডেট কেছ ষ্টেটাছ ৰিপৰ্ট। লাভন্য হাজৰিকা। হয়, লিখিছিলে নে? লিখিছিলে। Up to date case law. Up to date case status report.
It was a family.
Yes. What do you have to say?
Mr. Bosho was there on the last occasion. He said that charge sheet is submitted.
They have informed that Sassit was submitted in the last occasion. Maybe Lordship may allow some time, then in the report I call for, they'll send Lordship.
Last month only, he said.
Last month, stated Lords. Today itself.
Abatement to suicide is not a very easy proposition, and we have to see the direct connection.
See, basically, it is clear here.
That on that very day, there was a fight and all.
No, there was a long family dispute with
Long pending.
their property,
Hmm.
particular land. Now, prior to the incident, she went there.
Went to Jorhat.
Now, one of the accused is also an advocate of the Jorhat Bar.
Hmm.
Now, there is this, prior to the incident, there was some hot discussion over phone with
Hmm.
few people.
Hmm.
Two of the mobile handsets have been seized.
Much.
That report is not available before the court. And the case diary or the Xerox copy of the case diary or the scan copy of the case diary have to limited. Because earlier IO was transferred,
Acha.
the new IO have. And it is available till that stage. After the interim bill granted to the FIR named accused persons, they appeared before the IO, their statements have been recorded.
Acha.
And then, of course, subsequently they were granted. To that level, the scanned copy of the case that is there. But there is nothing in the record regarding the report of the mobile handset that is CDR call reports or whatever. It is not available in the case. So now, as Mr. Busso is saying that search sheet hasn't filed. So if you can have a copy of the search sheet, is fine.
Let us get a copy then.
That will be better.
And the reports on those seized mobile phones might also
Yeah.
come
Come, that may be.
after the last stipulation in the charge sheet.
What am I saying? Should we come to the hearing? And I'm at the online receipt for prosecutor actually for the state test number 1. On instruction. Ms. John submitted that after investigating the case. Police. In July 2024. Submitted search sheet. Normative case number 200 of the 2021. Involved in this procedure. Yes, when it will be possible?
Number two, he can get it today itself, but copy of the charge sheet will take some time. So oh,
But this is not a case of 482.
not a case of, there are some ingredients of direct connection with the suicide,
Some kind of.
some kind of.
That is the thing is can be said at this moment.
What my learned friend is saying that we can only get the number and the date. Getting a copy of the charge sheet would be difficult to the police's end.
Will you be able to let us know by today?
My lord.
Will you be able to let us know by today?
Yes,
Number,
today itself, lordship. He'll send me a written report.
We'll fix a date.
My
We'll ask the CGM to give us a copy of the.
Yes, my lord. And today, as soon as I receive, my lord.
Okay. Mr. Busso, when will you be able to give it to us?
My lord, today, within,
In the afternoon?
Yes, my lord.
By 2 o'clock?
Yes, my lord. Yes, my lord.
We'll fix a date later. We'll ask the CGM to furnish us the copy of the search sheet.
My lord.
2 PM she can come, 2 PM. Can copy of the LCR has come.
May I please, your lordship, as per direction of this honorable court, lordship. May I please, your lordship. Lordship, this criminal petition is filed by the petitioner of lordship for quashing of a lordship PRC case number 2098 of 2020 lordship pending in the court of SDGM Silchar lordship. As per direction of this honorable court lordship, the petition number 1 and 4 are supposed to file the joint affidavit lordship. And that was already executed lordship on 19th lordship by both the petition number 1 and 4 lordship at Silchar lordship.
Settlement.
But lordship, I could not able to file it lordship on record lordship. Lordship, I am having it. Lordship. If your lordship take it on record lordship.
Oh, Boroda.
That was an agreement lordship, joint agreement in the form of LTD law.
এইবোৰ মুভিটো মানে একদম মোৰ ভাল। Cognizance looks like among the separation. Very fun. Transfer it after.
Already, wife or already married, usually already separated. They are going to
You filed the joint petition.
Sorry.
You filed the joint petition.
This is already a joint petition only.
No,
He can,
Don't get it.
There's a
Ah.
deed of agreement.
he can file an additional affidavit. He has already given a copy of the affidavit, no?
Yeah, copies of the now given.
নহয় নহয়, এইখন কি লগাই আছে? এইখন এখন আছে যে?
So you can joint of deed of agreement, joint activity.
এইখন নহয়।
So you can issue on it.
এতিয়া certified copy দিলা যে এতিয়া?
If you have total last week, you can flash a type.
ও আচ্ছা আচ্ছা।
Pursuant to the order dated 24/07/2024. The petition number 1 and 4. And directed to file a joint additional affidavit. Signed and shown by both of them. On or before 10th of September. East from 12.
You are also here. You're also here.
May I please, Lordship?
Yes, Ms. Zahan, this is another issue. Come to page number, do you have the copy of the petition?
27 has gone through the FIR.
Page number 37, the order.
You had filed a protest petition. Right.
The copy of the protest petition you will get in the additional affidavit. Do you have a
Yes.
copy of the additional affidavit?
Perhaps I don't have, I will take it.
I'll give it.
Right.
After obtaining the certified copy of the,
This is again two-line protest petition. Investigating officer without investigating the place of occurrence filed FIR. This is protest petition, no? But in the said case has.
come
Original,
to the second, the penultimate line
Lodged.
of page 37.
Final report is accepted and.
Rejected.
Rejected.
final report is rejected.
Let the case be registered as complaint case, original FIR.
It will be treated as complaint.
This is not proper, this is.
No, this can also be done, Lordship. That
Yes.
is decision, this cannot, either protest petition or the initial complaint can be treated as complaint.
That I am not aware, because.
Initial
protest
complaint cannot be
petition-
considered as a complaint. If it is 193, it's a case different. And the cognizance of the offense of its own. That's the power of the magistrate.
Yes. 192.
No.
But here, I don't think he has said that he has.
In any case, whatever it is, this is not challenged, neither they have challenged nor we have challenged. I am facing trial in this case. And here our initial deposition under 200 has been recorded. And the contents of the initial deposition and the second FIR is the same.
So we have come for quashing of the second FIR. The cognizance has been taken on the basis of inquiry under section 200 or initial deposition. Neither they are agreed by this or I am facing trial in this. The second FIR is a page 55. This is the ground in this case.
Same thing. Section maybe. Because I applied the same one. First applied the second. Date also different, occurrence also different. Yes. It will mark together. But this incident is different. Yeah. That's why she's not getting any hope.
Page 44 is the initial deposition, Lordship. Other is 200.
Yes, why should we first, last?
Lordship, so first FIR culminated into FR. Thereafter, cognizance has been taken. Examining her. The page 44 is the initial deposition. Now, it is same as similar to her FIR. In the second FIR, that is page 55.
No, our 202 statement that she has made at page 44,
44.
that relates to the first case, right? That relates with the Silchar PS case number 4012/2018.
Yes, yes.
Yes.
But that her statement deposition, may I please read, Lordship, with it? I am the complainant. I filed the case against my husband Amitabh Deva and mother-in-law Shankari De. My marriage with Amitabh Deva took place on 22/1/2018 as per Hindu rites and rituals. After 3-4 months of my marriage, my husband started demanding rupees 5 lakh from me and also demanded car, etc. as my father was already expired. As such, I could not bring the money. In furtherance of said,
May I please, Your Lordship?
My lord, in the last occasion, Lordship was pleased to call for the CD, my lord. Here we have received the instruction that her seat submitted, my lord. Here in this case, my lord.
Do you have the number? Just give it to
My lord. My lord, dispute is charge sheet number 429 of 24, dated 30/6/24.
Just a minute. 4290.
429 of 24, my lord. Charge sheet number. And date, my lord, 13/6/24.
13 or 30?
30, my lord. 30, my lord. The charge sheet may be called for, my lord.
Mr. B. Sharma.
My lord. My lord.
Counsel appearing for the petitioner, running additional of the prosecutors. On instruction submitted. That. After investigation in the case. Police, the concerned authority. While. Number 429/2024. Dated 30/06/2024. Submitted a search sheet. In dispute PS case number 165/2024. In which. The petitioner. They are finding accused. Call for the. Scanned legible copy of the. Here's the. Along with the search sheet. Relating to dispute PS case number 165/2024. Corresponding to. PN number. 1143/2024. Arising out of. Odal Bakra outpost. GD entry number. 633. Dated 29/02/2024. From the. Court of the Learned Chief Judicial Magistrate. From the. Placed on. 18 September.
My name may be reflected.
Yes.
My name may be reflected.
What's your good name?
K Thakur, my lord.
The justice shall lift the name of Mr. K. Thakur, Learned Counsel for the.
I am for the informant lordship, just one number 2.
And
BLE Sheikh.
what's your good name?
BLE Sheikh lordship.
Already. Okay.
Yes. It's been informed to the court today, my lord, that charge sheet has been submitted. And that is charge sheet number 118 of 2024, dated 31/7/2024. I may be giving the liberty so that I can obtain the certified copy and make it part of the record.
Pardon, Mr. A.K. Vinod, and counsel for the petitioner and Mr. K. Bushra, the discipline public prosecutor for the second. In persons of the order dated 050823022024, Mr. Russell and additional public prosecutor. Instruction of the inspector come officer in charge of Nunmati Police Station. Submitted that police, after investigating the matter, submitted the search sheet in Nunmati Police Station, case number 200/2021.
Next page of the report, my lord.
On 31/07/2024. Wide CS number 118/2024. Against the petitioners hearing. Under section 306 of the 34 IPC. In view of the above, the petitioners are allowed to place the copy of the charge sheet filed inside Nunmati PS case number 78. In this matter, by way of an additional affidavit. List on 18th of September.
18th of September.
By that time, copy of the written communication of the officer in charge from inspector of Nunmati Police Station. 28/08/2024. Placed before by Mr. K. Russell and additional public prosecutor. Be careful the part of the.
Case diary is there, my lord.
Case diary is not there, case diary will be with the court only.
That will be
Case diary, you
required.
have a part of the case diary is with us.
So, my lord,
part of
case
the
diary
case
will be required, man.
Let us see the materials in the case, search sheet, then we'll see.
Yes. Obliged.
Then I've got the report, Lordship. They are agreeable to hand over the, oh, her senior is not there. They no longer require those for further investigation. But the fact remains whether it can be given in Jimma, because if these articles were produced before the court, then criminal court as such cannot give Jimma.
under 451. Again, I have to see whether High Court under 482 can do it.
This is not 482.
Acha, acha.
This is criminal division.
This is revision. 10 of petition, I know.
Agree by the order of rejection of.
Ah. Then the order of the lower court is not wrong in a way.
That's what.
Otherwise, report is here, Lordship can see this. Burada. Oh, কিন্তু তুমি revision, no? No petition, no. এটা হেক ভুল নহয় এই যে আমাৰ হাইকোৰ্টৰ জাজমেন্ট যে আছে যদি প্ৰডাকশন আছে তেতিয়া ডিমান্ড দিব নোৱাৰে এটি প্ৰডাকশন হোৱা নাই
Or at best, they may approach again.
হ্যাঁ
It was rejected at that stage because the magistrate found that these particles are required for the investigation. That was the report of the IO. So, madam, they have place again. Data may approach the magistrate again at that point. The IO might say they are not required any further. And they-
But then again, the law will remain the same. Criminal court cannot give in Jimma. Lordship can see the constructive part of our High Court judgment, the final conclusion. Oh, I have no mobile phone.
CLD, I think so.
Mobile phone. Lordship.
Give us the citation.
Citation, I have the party's name.
Okay, doesn't matter.
Yes, this is State of Assam versus Ram Shankar Maurya. Ram Shankar,
SHAN.
SHANKAR, MAURY. MAURYA. Criminal petition is 284.
MOU.
MAURYA. I think the judgment was delivered last year, 2023.
Criminal petition.
Criminal, yes, criminal petition 284 of 22.
SH or SAN.
SHANKAR,
Okay, SHA.
AN, Shankar. Oh, is there a High Court judgment as well? Supposed to produce school of the Jimadi Banara. Ram Shankar Maurya.
MOU.
MAU. This is what it is. I'll just try to find out now.
RYA.
MAURYA.
Do you have the number? Because I'm trying in the kiosk.
Acha, that will be helpful. Number is 294, 284. Criminal petition number 284. That will of course come in our website. 284 of 22.
Two 89,
289,
284.
282. This is what the lower court wrote. Acha.
Oh.
This is by Justice Michael.
0.
চশমা খোলা আছে না? ও আছে? The last paragraph, I've just taken out from the Google. Lordship may go to the last paragraph.
Yes,
Pale, no? In view of the reasons stated above, we answer the reference by holding that an investigation stage. Seized articles cannot be released by a court under section 451 CRPC. However, under 457, the criminal
order
court.
has been passed in 284.
Acha.
284. That's the what the judgment. 284. It is a different case.
Acha. But there are so many cases. There are
There
two
are
cases.
Many cases are there.
Huh.
So that it is, it was decided in 284.
Acha, acha.
And the directions have been given in the other cases. Okay.
Huh. Judgment officer, huh? Oh, Sundar Bhai pisod. Sundar Bhai to any general proposition, no. Yet, 51, 47 are difference to person.
No, it is liquidation. This paragraph 45 of the judgment passed in criminal petition 284. Where is 284?
Is it starting with in view of the reason stated above?
284 এ দেখা যাচ্ছে। এটা হলে হিটু আহিব নেকি? 284 বাকি থকা কেছ বিলাকত আহিব চাগে। আপলোডিংত গন্ডগোল হৈছে নেকি? You have found where?
Arship?
You have traced where? Because the leading case was 380, 355 probably.
Here it is showing us 284 only. 284 criminal petition. I'll just try to find out from 284. No?
Sharma, the comfort. The Google from are you like? So what did 284 was? 284 2020.
সেইটোৱেটো 284 এটা পোৱা নাই যে পাইছো পাইছো। 21/7 নেকি অৰ্ডাৰটো? 7 টো নহয়। কেনেকে PJ চাইকিয়া হ'ল? নহয় নহয়, ডিভিজন বেঞ্চ হয়।
কিন্তু কথাটো কোনোবা এটা কেছতো থাকিব লাগিব ন অৰ্ডাৰটো।
মানে এইটো লিংকেজ বুলি এনেকে
প্ৰব্লেমটো হৈছে মেইন সেইটো মই তোমাক কৈ আছো। লিখি দিছো পেৰাফোৰত। In view of the past by the court in criminal petition number Iman, the petitioners are directed to approve the charge of sitting custody of this.
This is a division bench order, Lordship, cannot be a single bench. This is by Justice Michael Jothankuma and Justice Malashri Nandi. This is a division bench order. This was referred to a larger bench. The question was referred to a larger bench.
Can you give us same party?
Same party, State of Assam versus Ramshankar Maurya. I'll bring it tomorrow, Lordship, because internet is not working. Otherwise, we'll get it in Manupatra.
Just a minute, we might have it.
It's.
We might have it. We
Yes.
have it. We have it.
That's
Thirty-one page, nalagi. 31 page, no, at side also.
You live log paisa, no?
It's a delay.
Did your Lordship get? Then there are so many deliberations on this point. Last paragraph would clinch the issue. In view of the reasons stated above, did your Lordship get? We answered a reference by holding. Last but one paragraph.
Yes, now what do you have to say here, madam?
Lordship. If it is not produced before the criminal court, they can do it. But if it is, they cannot. Produce one. Produce one. It's my instruction. Reported that Tulanam did not appear before me, nor submitted any documents, therefore ownership. It is seen that the ownership are not ascertained by the IO consent.
Where is that mentioned that it has been produced before the court?
This is what it is not mentioned. It is during this investigation. Yes. And during investigation, police can give in Jimma.
That's what.
This is provided under 451. But since court cannot, if it is produced before the criminal court.
No, if you come to the impugned order,
Lordship.
the IO has reported.
IO report.
Ma'am, where is your application? Do you have a copy of the application?
Yes, Lordship.
Have you annexed there? You have not annexed.
Application not, Lordship.
Do you have copy with you?
I have to obtain certified copy, Lordship.
Four fifty-one to Noari, which is during inquiry of investigation, so 457. ৰিপৰ্টে ৰিভিল কৰিব প্ৰডিউচ কৰিছে ৰিপৰ্টে ৰিভিল কৰিব আমাৰতো নাজানো অৰ্ডাৰ শ্বীট চাব লাগিব নাই কৰা যাব কিয় নকৰে প্ৰেক্টিছটো নাই তোমালোকে পুলিচত গৈ এপ্লাই কৰিব পাৰা উইদাউট কামিং টু কোৰ্ট পুলিচে যদি এগ্ৰিয়েবল হয় চাৰ্টিফাইড হৈ থাকে এনেকৈ পুলিচে Already a dispute over the police critical. And making up for an extended to Najan.
You don't have a copy of the application. Okay, we are fixing this matter next week.
Lordship,
You get the
Lordship,
copy of the
Lordship,
application and the orders passed on that application by the learned magistrate prior to 19th of March 2020.
Lordship,
Those two.
Lordship.
We are fixing it on 9th,
Lordship. Before that, I will fill Lordship.
list on 9th, Navalina. I'm as the Borough Council for the petition. Replace the copy of the application. File before the learned chief judicial magistrate now. For the Jimma of the vehicle and the mobile sensor. The orders passed by the said magistrate. In the application of the petition. The copy of the Jimma petition number, 408/2050.
Much obliged.
That report will become a part of the records.
The report of the concerned investigating officer of Nagaon case number 1250/3023. Clearly put the court today by MS as Jahan Additional Public Prosecutor. Relating to the issue involved in this petition, be kept as a part of the rest. No representation on behalf of the petitioner on fraud. List after 2 weeks on a date to be fixed by the list.
Wait, please, Your Honor. Also, this petition is filed for
Mr. Sharma will refer.
passing of the.
Do you have the case there?
My lord, I have received the information, my lord, that charge sheet submitted in this case also, my lord.
When?
And that is also earlier, my lord, 31/5/2022, my lord. And charge sheet number 23/22.
Yes. Okay, even such sheet submitted also lordship can pursue and pass down matter lordship. This is a private dispute lordship, family dispute and lordship hide agreement, okay. That is on page 19 lordship annexure 2. Lordship K has also appeared. Respondent number two.
May it please the Lordship, I'm appearing on behalf of the respondent number 2. Lordship, in this matter, they have already settled their matter outside the court, Lordship.
Not Mr. Registrar. No, counsel for the petitioner. You are Mr. Sharma, right? Yes, that's one. And MS S. Prakuti. That counsel for the response number 2. Also heard Mr. B. Sharma, not additional for the prosecutor. I will provide you additional for the prosecutor. The response number 2. Please take your seats. The legally married wife of the petitioner. And they were married on 25th of July 2021. The resolution number 2 on 29/04/2022. Laws that were written as I heard before the officer in charge of North Guwahati Police Station. And on the basis of the said FIR of the resolution number 2, North Guwahati PS Police Station case number 42/220. No, 2022. Under section 498 AIPC, reduced section 4 of the Dowry Prohibition Act was registered against the FIR and accused persons. Corresponding to GR number 692 14 bracket K of 202. However, however, thereafter the petitioner filed a petition under section 27 of the Special Marriage Act 1954, seeking dissolution of his marriage with the respondent number 2. And decree of divorce before the Principal Judge Family Court, Kamrup at Guwahati, being absued in bracket civil case number 47720. As both the parties during pendency of the said North Guwahati PS case number such and such, and the absent civil case number such and such, on detailed discussion pertaining to their marital dispute, they are realizing that their marriage has been broken, that there is no scope of reunion between them, and therefore they jointly decided to dissolve their marriage by decree of divorce on mutual consent. Where in this agreement, you have not mentioned about the criminal case.
One mention 42 of 22.
FIR number.
Para 21. PS
So
21.
para 2 is there.
No. Paste para 2. Paste 21.
And also decided to withdraw the FIR. It was lost by the respondent against the petitioner before the officer inside of North Guwahati police station. Observing that. There doesn't have any objection or passing of the same proceeding. In that regards, both the petitioner and the respondent number 2 have entered into a deed of agreement on 09/12/2023. Shown before the notary at Kamrup Metro Party. Today, Ms. Prakatil and council appearing for the respondent number 2 as informant or relating to non-party police station case number assassination submitted. Both she and the petitioner have resolved their disputes outside the court. And she doesn't have any objection if the proceeding of such and such is first, as in the meanwhile. Her marriage with the petitioner has been dissolved and she received the alimony in terms dissolved. What about the case before the family court? What happened in that man?
Should there one case, FC civil case number, divorce. Divorce. case.
That case, what is the status?
This has been the last stage, Your Honor.
Right.
We will file the joint petition on the next day.
Okay. In that regard, in that regard, the petitioner has enclosed the annex, a copy of the deed of agreement. Signed on such and such, so only put it for annex 2. Respond number 2. Next, during deliberation of the matter, Mr. B. Sharma and additional public prosecutor on instruction submitted that the police, after investigating the Segnon Bounty Police Station case number such registered on the basis of an FIR lodged by the respondent number 2 on such and such, submitted the search sheet on 31/05/2022 by charge sheet number 23/2022. 23, right?
23, my lord. 23 of the 22.
Presently pending before the Court of London. Chief Judicial Magistrate. Kamrup at Aminggaon. Nikhil, as the matter of on decided. Such. The proceeding of non-Guwahati Police Station case number such and such is accordingly set aside in clause in exercise of the power under Section 482 of this. Consequently, the search sheet number such and such file in sets is also set aside first. The above observation direction, which the petition, this criminal petition stands allowed to the extent above.
And you're blessed.
Maybe Lordship. Lordship application 528 Lordship. Quashing the NBW Lordship. So here in this case Lordship, this is the appearance stage Lordship. So the subordinate code in as much arid Lordship, the NBW Lordship, the page 24, annex of 5 Lordship can be find Lordship. Page 24 Lordship. The Nogao CGM in as much arid Lordship. Mary Lordship is 20 fine. It's a appearances. The Nurul Amin is a petitioner Lordship. The accused person has Muslimuddin, married Lordship.
Okay. You appear on 3rd of September,
Yes, Lordship.
only till that date.
Yes, Lordship. Yes.
Then the court below will consider, my lord, as per
Thereafter
law, my
you
lord.
also-
My lord,
Yes, Lord.
my lord. My lord.
Building till the date of appearance. The order of NBW issued by the land. Additional Chief Judicial Magistrate. In PRC case number 693/2017. Additional Chief Judicial Magistrate Nagaon. Arising out of Koswa Police Station case number 158/20. Under sections 147, 148, 149, 448, 128, 302, 326, I guess. Because of non-appearance. Before the land court in such and such. The learned Additional Chief Judicial Magistrate. Nagaon. In said PRC number 693/097. By order 29/05/2024. Is a non-bailable warrant of arrest against him and two other accused. Other four accused. for the appearance, fixing the matter on 0309 PD. Said order. Such and such. The order of non-dealing warrant of election. Against the petition and English such and such, some of the sentences. Shall not be executed. Against the petition. 0309 to challenge. Issue in such case number. In 0309 to present. Such and such the petition will appear before the language. The above observation direction case. The only petition stands allowed the action.
Much obliged.
It's a reminder. Today. Court of Learned Session Judge Foxo. William Beckett. Public Additional Session Judge. Bozari Patsala. The scan available copy of the records of special Foxo case number 11/2016. That was called for by order dated 26/07/2024, placed on 25th of September.
My lord. Obliged.
Please, your lordship. Service is not completed, lordship. Respondent number 1, 2, and 3, lordship. Last occasion, lordship has sought from the report of the.
Already have taken stage.
Earlier, we have taken, again, lordship, 22/8, lordship, we have taken first steps, lordship.
So,
Complaints report.
They submitted. Well, on counsel for the petitioner, the good name,
Peter Dutta.
that person to be order of the Lodging Court dated 22/08/2024. The petitioner have taken first steps for service of notice. The response number 3.
Yes, lordship.
By the registered post AD on 22/08/2024, and that service report. Number 1 and 2, but only all 3. Just a reminder. For the records of scan copy of the legible scan copy of the records of complaint case number 2812/2019. Report of Learned Chief Judicial Magistrate from Metro Guwahati. Has been directed earlier on 7/8/2024. Placed on process till then.
Lordship, interim order is there. Lordship, interim order is there.
We have
Publish.
extended- Yes, Ms. Das was here earlier. Ms. Zahan,
Lordship.
Ms. Das
Oh,
was here
it's
earlier.
19.
Lordship.
FR is submitted, I'm told. FR number she has given.
This is Vishwanath Sareli.
This is Vishwanath Sariyali. Yes. This is FR number 46 of 23. And dated 3rd of November 23.
46 of 23.
Yes. Dated 3rd November 23. 354, 376, no? 420, 506, everything. Washing of FIR. Washing of FIR.
Submit হয়ে গেছিল।
Mm-hmm.
FR submit হয়ে গেছিল।
Hmm.
Do you have the
I don't have the copy of the FIR.
no, but you have the 11 case number?
Case number. Case.
61. FR is
Case number is 61 of 20, no?
2020.
2020, yes.
Sections are aware.
61 of 2020 dated 19 to 2020. Bornali Hazarika is the complainant.
Okay.
Ane?
The last one number 2.
I did. Me letters. Lordship can see the sheet of paper that the police have sent. The FR number.
04 on 04022020. Lost the Nepean affair before the officer in charge of Parliament Police Station, Panbajar, Guwahati. Against the FNM accused persons. Alleging various offenses against the FNM's accused persons. The present petitions. Full stop. Let's take your seats.
Lodge.
On the basis of the said affair of the respondent number 2. Parliament Police Station case number 23 of 2020 under sections 354 in bracket capital A, public 354 in bracket C, public 376, public 420, public 506, public 34 of the IPC, read with sections 3 within bracket L1 with the How many affairs were there?
Only one affair.
What is annexed to?
Annexure. That is a different affair, Lordship. This is regarding one affair she had filed for against another person, similar kind of affair.
3L11 Nikisa, about 3L12 of the Civil Cost and Civil Private 1989, corresponding to GR number 1724/2020 was registered when the present conditions. Later, the said all one police station case number such and such. On the basis of affair lost by the resolution number 2 was transferred to the Senate Sariali Police Station, wherein it was registered as BNC PS case number 61/2020. The petitioners filed this criminal petition for setting aside and cause the said Parliament PS case number 23/2020 public BNCPS case number such and such registered against them under sections property. 354 within bracket capital A, 354 within bracket capital C, 376, 420, 506 only 34 in the IPC. Graded sections 3 within bracket 1, within bracket small Roman 11, and 3 within bracket 1 numerical 1 within bracket Anyway, tomorrow, Roman small field of a civil person and general types in bracket present general electricity at 1999. During the deliberation of the matter on instruction on us as Zam Lanet, additional public prosecutor. Submitted that police, after investigating the matter, submitted the final report in said prison of Surrey Police Station, case number 61/2020. Within bracket, arising out of government case number such and such. Five, FR number 46/2023. Dated 03/11/2023. In view thereof, this petition being Foxos stands dismissed. Okay.
Matter is closed, Lordship.
Here is the office note.
28, 2024.
2024. Service of notice is complete. In all the respondents. All the respondents. List this matter for admission. Because the registry has also received the relevant records. List this matter for admission on 6th of September. List.
Same letter. Office note is also same.
Some order. List allow much. About this number. No? Okay. Same order.
Lordship, may not be tagged, Lordship.
Why?
Lordship,
Why?
parties are different, Lordship, and amounts are also different, Lordship. The only college and the petitioner is same, Lordship.
That is why, you see.
Please, your lordship. As per office note dated 21st of August, lordship, LCR, scan copy of LCR is not received yet, lordship. Moreover, lordship, petitioner number 2 is expired and the date report of petitioner number 2 is already produced by the registry, lordship, and available with the record. So for petitioner number 2 is concerned, lordship, her name is omitted from this proceeding, lordship. Registry collectors, concerned police station. Lordship, informant respondent number 2 is also expired, lordship. He was one deputy secretary to the Govt of Assam Education Department, lordship. But that report is not available with us. So kindly direct the registry to collect that report from concerned police station. As per office note, lordship, the notice is returned uncharged.
Ms. Zahan, the matter is pending before the special court.
Hmm.
So it is not possible to have the records, do records of an earlier call for. The informant in his official capacity has filed the FIR, so in the absence of informant, there is nothing to wrong about. Though he has expired, his
Hmm.
is not required otherwise. In his official capacity, he has done it. Now, just the status, because you see this charge were framed in July 2014.
Hmm.
This petition has been filed in 2021.
Yes. And in the years 2017, few of the charges were quashed.
Yes, Lord.
That's right. So now thing is this, at this stage, will not call for the records, will not insist on that.
Hmm.
Just let us know the status of the proceeding.
Gotcha.
That will do.
Perhaps there is a stay as an. Oh,
There is no stay. I believe.
there is no stay, I'm told.
There are total 97 witnesses. So already 57 witnesses have been taken.
Give us the details.
That perhaps registry can bring it from the Court of Session Judge, special judge. The present status, I think they can bring.
We can do that. Okay. Pardon, Mr. M. K. News, counsel appearing for the petitioners. The officer in charge of Lilaveri Police Outpost by its communication dated 28/12/2023. I apprise the court that the petition number 2, Srimati Niroda Dole Pegu, wife of Kripanath Pegu, resident of village Saboti Misingao, Lakhimpur, not Lakhimpur, district Lakhimpur, not Lakhimpur, district not Lakhimpur. Expired on 21/10/2021. To that extent, copy of the death certificate said Srimati Nirara Dole Pegu, as well as the certificate dated 28/10/2021, as well as certificate dated 27/12/2023 issued by the government village headman of Saboti Sanmari, not Lakhimpur, have been placed before the court. In view of the above, the name of the respondent number 2, তারা কথা লিখে। It is also seen that none of the legal heirs of the petition number 2 after her death on 21/10/2021 approached this court in this matter. As such, the name of the petitioner number 2 be deleted from the cost title. Registry shall be ordered needful according. It is also seen that the respondent number 2, the informant of the case in his official capacity, have lost the official capacity, lost the affair of the case as an informant. In view of the, as such, the state represented by the public prosecutor shall represent the said respondent number 2, the informant of the case. List on 27th of September. Learned Special Judge, Assam, shall apprise the status of up-to-date status of special case number 05 of 2011. Registry shall obtain the report regarding the up-to-date status of special case number 05 of 2011 from the Learned Special Judge Assam. Okay.
Obviously.
Last occasion, this honorable court directed the PP to place the relevant materials along with the status report of the case, Your Honor.
No, the intimation have gone, but today I don't have it. Wait. Fully. After the case report. Gorsuk ni Fatahil Ambari. Yeah, Gorsuk CD to be written into Asil. 21
Gorsuk. Because the Potasi Lambari police station case has been transferred to Gorsuk police station.
Acha. Our intimation had gone long back in 21. Lordship will give us another date, we'll bring it. Gorsuk only.
Last order was passed on 26th of July.
Acha.
Tell us when you'll be able to get it.
Lordship, any date. Try to step level.
13th of September.
13th of September, positively, huh? PD.
Because there is an interim order in force.
Up to date.
That is the difficulty. An interim order was passed on 15th of June 2021.
15th of June 21, since 10.
Everything has been stalled.
Everything has been stalled.
It's on 13th.
Lordship 13th. 13th of September. Gorsuk. Submission of report.
No, the relation of the prosecutor and the surgeon is placed here.
Has been already returned into FR.
Relevant instructions
The original has been sent to him. Itu Potahil number itu.
as directed earlier. 15/06/2021, 10/11/2021, and 26/07/2024. Relating to Gorsuk Police Station case number 47 of 201. Arising out of, which was initially registered as Potasilambaड़ी Police Station case number 17 of 2008.
Otherwise, there is a communication here. Potahil Ambari case 17 of 2018
Which was
had
just-
returned in FR.
The matter was, don't know what happened. Thereafter, matter went to Gorsuk Police Station. That's the report is.
Hmm.
You have that.
2018. I will get the present status, what had happened. Gorsu, which was transferred to Gorsu 47. 2018.
It was renumbered as Gorsuk PS case number 47, 2018.
Gorsu. This 47 of 2018. It'll take a good after 10 years.
Status report.
No, after the case. After that case diary, Lordship wants to see
Status of this.
the status report.
Or if you can get the case there, it's already stayed 2018 matter, 21 still matter is pending for no reason.
Interim order that may be continued, Your Lordship.
Till the next later.
I need to move forward.
Yes.
May I please? Yeah, this is, I has been come up for consideration, my lord, for suspension of sentence, my lord. But the applicant was convicted by judgment and order dated 13/9/2021, my lord, passed by Lana Special Judge Sipsagar under section 6 and 18 of the POSCO Act, my lord. And he was sentenced to undergo rigorous imprisonment for 10 years under section 6 as well as 18, further undergo 5 years under section 80 and as well as under section 10 of the POSCO Act.
Paper book is otherwise ready, Lordship, and
Your
take
Lordship.
up for hearing.
Your Lordship, may kindly see, my lord. The wife of the appellant, my lord, she lost the affair. She lost the affair after more than 40 days of the incident, my lord. After she left the incident, my lord. Now, if your Lordship take up the paper book also, if your Lordship take her evidence, my lord, then also no offense under section 6 has been made on, my lord. There was no penetration, my lord. That is, if you take up the paperwork, that is PW. PW2, my lord. Page 11. There was only touching part was there, my lord, showing a penis, and there was nothing regarding penetration, my lord. So if that is missing, my lord, necessarily section 6 will not come. At best, it can be a case of sexual assault, aggravated sexual assault.
18, 10, and 6 of 19.
6/18.
Six now, 10 or 18 now. Doctors. Dogs on the one. Presumption actually show our foundation of cancer. Contradiction assigned. 10 is 10. PW 10 is the previous number. Yes, I am.
Mr. Patashi, going to the 164 statement of the complainant, informant mother.
Yes,
and the victim, as well as the evidence.
yes, ma'am.
I think at this stage,
But there is no penetration, madam. So,
not required as such.
no, it's located, madam. Otherwise, because that is
Kindly see,
section 6, madam. Section 5 says, madam.
kindly come.
6 read with 18, 10. No.
Penalty with section 3, madam. There has to be a penetration, my lord. To the extent it will wear that. And a penis in the vagina.
Read 9.
Section 9. No, I mean to say that
Punishment is under section 6, right?
I was convicted under section 6, madam.
Punishment is 6.
And the definition is section 3, madam. And four is for punishment of penalty with sexual assault. 4 and 5 is aggravated.
Sorry.
Madam. Aggravated will, since I was the father, madam, since aggravated will come. And 6 is the punishment part, madam.
Actually, 18, half of the punishment.
That's that.
Half of the dinner.
10 is.
10. So 20 years double again or minimum under 6. Half the year.
I don't, it was from year 2019, 17 onwards. Before
This is, say, as per section 6, it is maximum, minimum is 20
20.
or life.
Yes.
But
No, that
considering
is
section
before
18,
amendment, madam.
Acha.
Our is of, this amendment was there in 2019, madam.
This was
Our-
before that.
Before that, it is a case of 2017, madam. FIR 2017, madam.
Oh, extend to life, but then the finding that he has given 18 years, 20 years, that perhaps that finding is little wrong if, because he had said it is 20 years is the minimum.
No, it is not that.
do you have the old one, old act?
No, it is there in the act, in the footnote, my lord.
Footnote only, the punishment is 10 years.
10, not less than 10 years, but maximum imprisonment for life. My lord, in this case, what has happened? Conviction has been given under 6/18, attempt to commit section 6. So under 18, the punishment is half. While court has not considered the minimum punishment, what the court has done, court has considered the maximum punishment of life. And when, my lord, fractional punishment of life is taken, it is always treated as 20 years, my lord. Going by that analogy, the court has given 10 years, my lord.
But attempt also, my lord, there is no ingredients, my lord.
That is also a little not correct because life is life.
Life
You
is life,
cannot
but
take
when fragmentation is done,
57.
57, then it
But,
is treated as 20.
So
That is what is
since
done.
the
It's
ingredient of
recorded
section
20.
6 is not there, 18 is also not there. So at best, it can be an offense under section 10. you know.
18 to penal, 18 to
Attempt.
attempt to commit. So it cannot be said that conviction was under 6. Conviction was not under 6. While reckoning 18, you have to consider it as 20.
William Langdon, he was in, she was in his position. He would have done
As far as 389 now,
618 or no.
389 no application of law. Prime officer her statement.
At best, it can be case of section 10,
Oh,
not as a 6 or 18.
6 9 दिया था नहीं
19
6 डेढ़ भी 18 है.
That means 18 or 9.
Attempt to.
When attempt will come. When I made the attempt, it was success. Then she was in my position. I could have done it.
Whatever. That is it. Attempt to process.
Then did I really? If I could not do some intervening thing has done. And I was no intervention.
And that will be seen in hearing.
What is that?
Hearing of that.
But we have intervention for
What? Hey, but then still she is not so young, no, 16 years. Too, but you could have.
unsuccessful.
Unsuccessful. Into her action, it shows no.
And the innocent was not formality. What it was in his conflict. That so
Contradiction of case in 11.
It is not good. Then it is a case to বহুত ধৰণৰ judgment আছে I'm always look for greater justice. We can see. Good corona. Itu to person ho gaya metric purpose ho gaya rokile. Many things can happen, we don't know. There are people, but our statement is consistent. আমি বলে বুঝতে পারছি। Thank God.
Oh, the applicant is in connection in jail in some other connection also? No. Yes. The order sheet clearly refers of 13th of September 2021. Today is fixed for judgment. Accused is produced before this court today from the district jail, Sibsagar, as he is in jail custody in connection with some other case.
Oh.
Yeah.
Yes, we don't know my language.
Driver-
Minor offense, the minor offense maybe.
Driver ही कौन?
Oh. Because that, no evidence has been laid that he was
No,
convicted of.
definitely not. But thing is this, but apparently this order reflects that he was already.
But that cannot be the count, madam. That's what
We want to add, since when? So basically in this particular POXO case, he was in, earlier he was taken into custody on. Was arrested. Seven, 2017.
At the time of trial, initially at the time of appearance.
7/7/2017 and was released on 5/8/2017. Not even a month. And thereafter, he was taken into, after the judgment passed.
Now, my submission before also, madam, at best, it cannot be a case under section 10, madam. Already 10 has a minimum 5 years has been convicted, madam. I have undergone more than 2.5 years, madam.
How come?
Because I was, because judgment dated is your also fine. It's 13/9, madam. So
13/9.
2011, 21.
22/23.
24, madam.
This will be 24, 3 years.
3 years already. So
And
half
3
of the
years, 1
punishment.
month. So not even 3 years.
So half of the punishment I have already undergone, madam.
How come?
After 5 years, madam.
Under which provision? 5 years of which section?
10, because section 6 and 18 will not come. So on that ground, my lord.
What do you have to say, Ms. Zaham?
That cannot be an aspect, like unless hearing is done, lordship set aside the other
But
section.
I will say from the material,
These are there.
from our statement, it's able, look,
No, one thing is, of course, some other inputs are there that learned trial court has considered in a different manner. But 164 statement of the victim and her evidence before the trial court, something remain intact.
Those are not
but no,
inconsistent.
That is.
I understand, but there is no penetration, admittedly, madam.
There is some contradiction. I've seen one line contradiction in her statement, but then it's not proved according to law. It was not placed before the IO.
Because
Otherwise, other things are
basically,
consistent.
my submission is just ingredient of section
If
6.
you read 164 of the victim and the.
Basically, our case is that if you take his statement testimony in the court, that is substantive evidence. Then section 6 evidence is not
No,
there.
6 is read with 18, attempt to,
Attempt also is not there.
and facts, lordship will
Because
see.
she was in my custody, at any point of time, I could have done it. There is no intervening circumstance which prevented from doing it.
But in 164, she has explained, also explained in her evidence.
I understand. No, I'm on to say that so far as penetration part is missing, my lord,
No,
then section 6 and 8 will not come. If I take his statement as a true at this stage, my lord. At best, it's a case of section 10, my lord. 10 is 5 years. I've already undergone more than 3 years.
6 was not exclusively taken. It is read with 18.
That way, 18 is also missing. Attempt is also not there.
Attempt perhaps is there according to the facts.
Very much there. Let's see.
Attempt is not there. Attempt is, if your lordship see, she is in my custody. I have control over it. I could have, penetration could have been done, my lord. Had there been some intervention in between, the matter would have been defined.
Lordship will take it up for hearing. I mean, prima facie,
Why,
the
sufficient, your
offense is
lordship,
made
I
out.
say. Why, when question of attempt will come, when I have attempted, I failed to do so. Some intervening, something else have taken place which I could not accomplish the job. That is missing. Where
Now,
is the
how
internal?
attempt will be interpreted, that we will see during hearing. Now, as far as prima facie.
From Homar's testimony, I am saying.
Hmm.
Where she was all along in my custody, my lord. That it is not a case that somebody that I was afraid or my mother intervened, nothing in that sort of. That
first you read this part of the 164, both of you.
164
is there in
next.
that record. Record, me.
Can you tell you the
Tell it with the
evidence?
trial. In fact, her 161 can also be seen.
No, your 164 is not a substantive evidence. Your logic can be used for corroboration,
No,
not contradiction.
as far as
That is what I was
Fox
saying.
But PW2 statement is that your lordship will find there's page 11, man. Her testimony, my lord. It is very clear, my lord. No offense of question of penetration as neither there is attempt to penetrate, my lord. Nothing is there so far section 6 is concerned. So far foundation that has been laid is regarding section 10 only, sexual harassment, a sexual act, my lord, without penetration. So at case which since he is a father, he get basically aggravated sexually without penetration.
Attempt to case of petition of Supreme Court চাও এতিয়া নহয় এতিয়া প্ৰাইমাৰ আৰু সেইটো কেনেকে আপুনি কৰিব এইটো এৰি পেলাই 5 বছৰ ধৰি পেলাই এনেকে আৰু বছৰ এইটো পতা নেকি
The formula system, no?
without going into the marriage without
The formula is because he is another one, honestly, is not into that.
সেইটো হ'ব 5 বছৰ থাকিলেতো সুপ্ৰিম কোৰ্টে এৰি দিব দিছে আৰু 368 নেকি 68 বি কিবা এটা 5 years 368 এ নে কিবা no 468 কি আছিলে 5 years 468 a 436 a 436 half of the imprisonment.
On 64 to another substance evidence now.
নহয় নহয় কিন্তু পক্সতটো এইটোৱে চাব দিছে ন আৰু কনসিস্টেন্ট স্টেটমেন্ট corroboration নালাগে যদি তাত পুৰা স্টেটমেন্ট কনসিস্টেন্ট থাকে
But testimony is very clear.
বেইল যে নাপায়
ইমান সময় যে তাকে কি কৰিব
কি এইটো কেছ কেইটাৰ
সাধাৰণ কিবা কৰিব মাইনৰ পইণ্ট এইবিলাক শিৱসাগৰ আপোনাৰ জেগা এটা তোমাৰ জেগা এটা
Remain intact 161 same.
Uh-huh.
In fact, 164, 160 she clearly mentioned, but in the during trial, whatever she said, she is in a lesser version.
Yes, those are more in details.
Those are more in details.
In fact, the Supreme Court has said her statement right from the police investigation to trial court.
But there,
has to be
but
seen.
there also there was no penetration, man.
No penetration. Six will not, six
So
rapid 18. Attempt.
Attempt also will not come, my lord. At base, it will be,
For attempt will not come.
because for attempt, my lord, you will also make kindly see.
Section 18.
In case of attempt has to be proved, my lord. Because first of all, for proving attempt, my lord, since she was in my custody, my lord, I have full control over her. There was no any intervening such circumstances which prevented from doing the act. Then only question of attempt will come.
It will attempt to Supreme Court must have interpreted, no? I have to ask one.
The manner in which she has deposed, my lord, I could have easily penetrated, my lord. So question of attempt will not come. If there will somebody has prevented from him doing it, or she shouted something there, which has prevented from doing the act, that question of attempt will come.
In her evidence, 161, 160.
I understand, but then also, my lord,
What she has said. Taking advantage of absence of my mother. My father is to gag me
yes, ma'am.
and throw me onto the bed
Yes, ma'am.
by placing himself on my body.
Yes, ma'am.
As a consequence, such and such, over
Detach
my
from my
body
body.
as well as on bed.
Yes, ma'am.
Now, that here she has explained less that from the charge under section 394 IPC. And set them at liberty, forfeit liberty, set them at liberty. Forfeit as the prosecution failed to prove its case against them. In view of the above, this criminal petition being in class was as dismissed. Copy of the judgment dated 172023. Passed by learned Chief Judicial Magistrate Kamrup Metro Guwahati in dated election. Inside GR case number such and such, be kept as a part of the record. Okay.
My lord, here 10 years conviction, my lord. We will have to file our objection in this case, my lord, in IA, my lord. And in the meantime, perhaps service complete or not. That is-
Complete, so much.
This is under 436.
My lord, for the distance.
There is the office note. Definitely. Seven, 2024. Service of notices complete on the response number 2 informant. The respondent to the state respondent is allowed to file its objection pertaining to the suspension sentence week the appellant on or before 12th of September, at least on 18th.
My lord.
W.
The ministry has already received the reports.
No, 18.
As per order dated 19/7/24, passed by your lordship, I have taken step of response number 2 for public prosecutor, my lord. And accordingly, I have submitted the acceptance copy before filing section. And office note dated 21/8/2024, my lord. No service report has been received in the office. Officer, state to the my lord.
Mr. Sharma,
My lord.
get the whole of the Patharkandi police station. Ask him to submit the report.
My lord.
Okay.
My lord.
Where is the office note dated 21/08/2024? List again on 16th.
My lord.
For the
Here-
report of
My lord.
the officer in charge of Patharkandi police station has been directed earlier on 19/7/2023.
Obviously.
May I please the lordship, my lord? My lord, this appeal, my lord,
Along with the appeal, my lord, one leave petition and condemnation of petition was there. Condemnation was allowed. Against the leave petition, we have taken the steps, my lord. Office note says we have not taken steps. That is the fact. Office note says steps not taken, but my record says steps. Alabama. Do you have the number? There. Second page, my lord. I have highlighted, my lord. Alabama taken, my lord. On leave, my lord, on leave application. Do you have the filing slip? That filing slip, my lord. That is not,
Regarding postal Telangana.
Yes,
Don't
ma'am.
have.
But it is confirmed, my lord, Alabama steps are taken, my lord. That is the fact remains, my lord. That may be put into record, my lord.
Where was the office note dated? 17/8/2024. I want Mr. PD Secretary Council appearing for the appellant. From the case details has been shown in the website of the registry of this court. Submitted that on 19/05/2023. Steps to postal Telangana was taken on the respondent, sole respondent. Registry shall verify the same and submit its report. List on 11th.
I'll oblige, my lord.
May please your lordship, 10 days time may be given lordship. Settlement is going on between the parties. There is possibility to matter is resolved.
We have the counsel for the parties list after 2 weeks and a date of the fixed release.
May I please your lordship? My lord, my senior is lagging another court. The matter may be adjourned for that day.
You are in detention since when? You are in detention since when? And if you have the counsel for the affluent materials available. For 2 weeks, so it's still become on a date to be picked by the registry after 2 weeks.
May it please your lordship. Condemnation application, notice has been served on respondent number 2. As per office note, there's a flag mark A. And none appears, it's a POXO matter.